Okay, so if you don't already know and you're living under a rock, the Supreme Court opinion, a draft opinion from the majority, was leaked that calls for the overturning of the precedent cases of Roe v. Wade and Planned Parenthood v. Casey. What that would effectively mean is that two major landmark Supreme Court cases would be nullified, and the result legally would mean that abortion restrictions or lack thereof are decided at the state level rather than the federal level. Many have been quick to react to this. There were barricades erected outside the Supreme Court last night. My wife and I were talking about it. We discuss this topic from time to time. It's a big topic of debate between us. And, we sort of were talking about really what the ramifications are and how this will change. So basically, if you're in a state such as Tennessee that has a stricter abortion law, one that, or Texas, I think, has one of the more famous ones, it simply means that that will apply there. And if you need to have an abortion, or if you choose to have an abortion, that's the way I would phrase it. There are states that will be having much more lenient laws, such as Maryland. I saw a tweet, for example, from someone saying, "Come to Minnesota, we'll take care of you here." And in fact, there are going to be, and I'm sure there already are, different private, non-profit organizations that offer to fund women taking a trip to a pro-abortion state and getting their abortion there. So those people that are hailing this as a big victory against abortion, or those that are lamenting that this means the end of the woman's right to choose, so to speak, neither of them are really correct. What this is that we return to the legal reality that existed before, I think it was 1972, when Roe was first handed down, when that decision was ruled upon. Here is Elizabeth Warren reacting to it.
Senator, how are you feeling?
I am angry.
Angry and upset?
Angry and upset and determined. The United States Congress can keep Roe versus Wade off the land. They just need to do it.
I've never seen you so angry. You seem to be...
This is what the Republicans have been working toward this day for decades. They have been out there plotting, carefully cultivating these Supreme Court justices so they could have a majority on the bench who would accomplish something that the majority of Americans do not want. 69% of people across this country, red states and blue states, old people and young people, want Roe versus Wade to maintain as the law of the land. We need to do that, and we have a right. Extremists, we've heard enough from the extremists, and we're tired of it.
Senator, does this open the door for other constitutional rights?
So that was Elizabeth Warren, and what she's doing and what other Democratic politicians are doing is saying, well, now we have to work to make it so that it is the law of the land, like literally. And she wants to put in place a federal statute that would make it a right for a woman to have an abortion. I don't know up until what point it would be. And that, I think, would be the major hurdle for the Democrats. One of the major hurdles. The other major hurdle is that they wouldn't be able to get, first of all, I don't know if they can even get a majority in the House at this point, this close to a midterm election, given that there are Democratic representatives in the House that may live in districts where, while the voting public is moderate, it's not necessarily the most pro-choice electorate. There are pro-life Democrats. There have been, from time to time, ones that have remained in the Senate and the House. Joe Manchin, for example, considers himself a pro-life Democrat. I don't know how he can live with himself if he is, given that he does vote to put on the federal bench many very pro-abortion judges. And likewise, I think that really this should be, unfortunately, a fault line on the political spectrum. If you believe in pro-choice, if you believe in the woman's right to choose, I think that it should be a fault line that puts you on one side of the aisle. And if you believe in the sanctity of life, you should be on the other side of the aisle. I don't understand why there are Republicans like Lisa Murkowski and Susan Collins that continue to skirt the issue and say, well, on this one thing, I think that we need. No, look, there is a very clear choice here, and people who want to waffle on it, I think, are, and I'm saying politicians, people in their own private lives who don't serve at the federal level or in any elected office. I think people have the luxury of contemplating, very theoretical ways to address an issue when they're not responsible for public policy. So if you're in academia or whatever, I don't begrudge people for having nuanced points of view. But people who are in elected office who like to make a lot of flowery statements about how they are sort of torn at this side and on the other side, I think abortion has to be a very clear-cut issue. And I think if you're elected to office, right? And I think that the middle ground has crumbled over the past 20 years because you see more and more the leniency being applied to the abortion restrictions in some states like Virginia, where they did pass a law that would even allow to terminate a pregnancy after it's over. So terminating a live infant. And this is something that's very emotional for some people, but terminating a person that's already born, what is that even called an abortion anymore? That is something that is that's something that in Virginia was already proposed and adopted. I think New York also has a similarly lenient legal structure for their abortion in New York State. So, in my opinion, it's a very pointed issue, and I think discussing it obviously raises a lot of emotions. But as a politician, these people have to be willing to stand very firmly on a certain side. And unfortunately, Susan Collins, I believe, stands on the wrong side of the issue while claiming to be a Republican. Lisa Murkowski as well. Joe Manchin also on the other side. So what actually happens here? So you have state laws, and this is from the Guttmacher Institute. They're actually, I believe, rather pro-abortion. They're also pro-Roe v. Wade. And these are state abortion laws. And this is why I think that it's important to think about Roe v. Wade does not allow for actual specific policy insofar as abortion is. So when it was ruled upon, there were many questions that were left open, such as exactly how long is a fetus viable? Things like that. So I have to minimize the screen a little bit so you can see all of these different columns. So these are some of the major legal questions that arise in the issue of abortion's legality. Okay, and we're not going to read through every single state, but you have, for example, does your state require a licensed physician to perform an abortion? We'll get back to that. It must be performed in a hospital, if at all. Second physician must participate, if at all. Prohibited except in cases of life or health endangerment, if at all. Partial birth abortion banned. Public funding of abortion, whether there are funds all or most medically necessary abortions or funds limited to life endangerment, rape, and incest. Private insurance coverage limited. So you can see that there are several states where a lot of these are They are. I mean, the the notation here is kind of complicated. So down means permanently enjoined, law not in effect. So there is a law, for example, where you see this in Alabama, where a partial birth abortion is banned, but apparently the law has been enjoined through some sort of court case. You also have the same thing in Idaho. So this is where there's been the most litigation concerning partial birth abortions. You have exception in case of threat to the patient's physical health. You have exception in case of rape or incest. That's a very interesting scenario, because today I was listening to an interview with Pennsylvania Senate candidate Kathy Barnett, and I was actually very convinced by her. Not to say that it's not a complicated issue, but she said her birth was the result of a rape. Her mother was raped when she was 11, and they kept the pregnancy, and she was born and born into not very good economic conditions. So some people would sort of question the whole supposition that you should include an exclusion for rape or incest. But then again, so taking it to the other side, the common argument is, if a woman was impregnated against her will, does that not constitute an imposition and violation of her choice if she's forced to remain pregnant? That's, I think, also a very convincing argument on the pro-choice side. So even though I'm a very pro-life person, it's hard to sort of ignore very compelling scenarios where you're like, well, are you at this point only protecting life, or are you also sort of burdening and in some cases making worse a situation for a person who is not capable of coping with a pregnancy? There's this one, exception in case of life endangerment only. A 2016 New York Attorney General opinion determined that the state's law conflicts with U.S. Supreme Court rulings on abortion, and that abortion care is permissible under the U.S. Constitution to protect a pregnant person's health or when the fetus is not viable. Here they're even using the term pregnant person, which I think invalidates this entire... So the entire perspective becomes absurd when you say that, well, men can become pregnant too. Well, I thought this was a women's rights issue. Omega. So you see all of these notations. Exception in case of fetal abnormality. So if and that is a really hard choice for some people. Theta. Despite a court order, the state Medicaid program does not pay for medically necessary abortions. Zeta only applies to surgical abortion in New Mexico, but some but not all advanced practice clinicians may provide medication abortion. Phi, law limits abortion provision to OBGYNs, and I think this is the Eurosign or ETA. A court has temporarily blocked enforcement of a Mississippi law that would have banned. So you have all these little cutouts. So this is what I want to convey to you. Even with Roe v. Wade, basically standing for the past 50 years, you have a lot of open questions that remained standing as to how far that right to choose is covered. Some people say, well, a woman should be able to have an unobstructed right to choose to abort a pregnancy all the way up to birth, regardless of the circumstances. Some people, and then you have things like this. So if the right to choose is upheld, must it be performed? So should the abortion be performed by a licensed physician? Believe it or not, there are many states where you don't have to be a licensed doctor to perform an abortion. California, Colorado, Connecticut, DC, Hawaii, Illinois. So the usual suspects: Maine, Massachusetts, Montana. Even I mean, that's kind of surprising. New Hampshire. You have Oregon, Vermont, Virginia, Washington, and West Virginia. In all of those states, you don't even need a physician must be performed in a hospital. So that's not actually very common. So these are a lot of different restrictions that are, and then you have other issues whether providers may refuse to participate. So if abortion is healthcare, then that also leaks into the big debate over whether healthcare should be a public or private endeavor. And people who support the public option or universal healthcare often will say, well, this is so that healthcare providers can't deny a woman the right to choose. Well, now you're bringing in a different issue. So now, because there are healthcare providers that say, well, we don't really want to cover this procedure, people are saying, well, she has the right to this procedure, ergo, you should not have the right to be in business to sell health insurance. So there you see, okay, and I get that some people have other reasons for supporting universal health care, that the debate over abortion is expanded in order to start to encroach on other areas of public policy, right? Mandated counseling includes information on breast cancer link, fetal pain, negative psychological effects. So I think in Ohio, it is required for fetal pain and for, we don't have any requirements. So in any case, and I might do a video later about current electoral issues in Ohio. There is an election today in Ohio for the primaries in the Democratic and Republican races. So I think that people have to grow up and realize that Roe v. Wade did not solve the abortion issue. If anything, it complicated it a lot, right? It complicated it a lot because you have many questions that have cropped up as to what extent this right, quote unquote, extended. We're going to go to Twitter. This is John Turley. He is, or Dr. John Turley, the Shapiro Chair of Public Interest Law at George Washington University, and one of the more well-known constitutional lawyers in the country. And he's been known to take controversial positions. But here he is. He says, those lionizing this leaker are showing the license of the age of rage. Consider the tweet of Ian Millhiser, a senior correspondent at Vox. Seriously, shout out to whoever the hero was within the Supreme Court who said, F it, let's burn this place down. Those words show the sense of release and impunity that comes with rage. No institution, no principle is a barrier to seeking results by any means necessary. So this is also, so he also says, Brian Fallon, former Clinton aide and head of Demand Justice, asked, is a brave clerk taking this unprecedented step of leaking a draft opinion to mark the country what's coming in a last-ditch Hail Mary attempt to see if the public response might cause the court to reconsider? And he continues, this brave clerk committed an exceedingly unethical act that would qualify for disbarment. However, Demand Justice not only pushed Breyer to retire with a public campaign, but has pushed for court packing. It appears that, like court packing, it is all part of the by any means necessary mentality that has taken hold on the left. He also says Chief Justice Roberts just confirmed. So there was controversy over whether it was a real document. So Chief Justice Roberts just confirmed the legitimacy of the leaked opinion and the initiation of an investigation. The message is clear. May God have mercy on your soul, for I have none. I mean, did he? Did he say that? If he did, that's a little uncharacteristic of Justice Roberts. So, from what I understand, the opinion that was leaked was voted upon by Justices Clarence Thomas, Samuel Alito, Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch, leaving four others who did not join, which would be Stephen Breyer, Sonia Sotomayor, John Roberts, as well as Elaine Kagan, I think her name is, Elena Kagan. So you have probably a 5-4 split or a 5 5 people joining the majority opinion written by Justice Samuel Alito, maybe a concurring opinion by Justice Roberts, or maybe an opinion concurring in part, and then a dissenting opinion by the other 3 justices who constitute the liberal wing of the court. And I think it's completely fine. If some people want to continue to agree that Roe v. Wade was a good legal decision, which I think is absurd, but there are people who have fought for many years to uphold it and have legally defended it for decades, or have been and look, those of us who are not lawyers probably have not really explored all of the arguments that are in Roe v. Wade, or people who have not been advocates on the issue on either side. So there's a lot of ground that people who are just casual members of the public don't really cover day to day, because they think, oh, Roe v. Wade, all it does is it guarantees the right to choose. No, there are many, many, many tough legal dilemmas that are created by the Roe v. Wade decision. And therefore, that's why for so many years, not only is it controversial because of the religious and ethical connotations to the whole debate over when is a fetus viable, when does life begin and everything, but also, like, how do you enforce it, and how is it, when does it become really public interest to restrict something that is something so private to people's personal choice. So I feel that it's okay to have different perspectives. And then that doesn't mean all perspectives are correct, but it means that you have different people interpreting the law, interpreting public morality in different ways. It's not wrong for people to have different views on those things. But Jonathan Turley is right. There are people who are saying, well, we have to take special action at this point. There has to be somebody willing, and they think this guy who, or lady, this clerk who leaked the draft opinion, and they say that this is a brave thing. That's not what it is. At a certain point, it becomes basically, these actions are meant to circumvent the real judicial process. The judicial process is limited to those 9 people. They're going to start saying in the next few months, all of this rhetoric is going to be about how the Republicans and their justices and Donald Trump, they took away your democratic rights, and therefore you have lost the right to choose. What was Roe v. Wade? Roe v. Wade was the usurpation of a democratic right. Up until then, the abortion laws had been made by state legislatures and by governors who had been elected, so all elected officials. And Roe v. Wade was decided by who? By the Burger Court, by Justice Harry Blackmun and all of the other people who joined on that opinion. I think it was a 7-2 opinion, but nevertheless, none of those people were elected. So Roe v. Wade itself was not a democratic act. It was an act of judicial activism by people who were unelected, and therefore people who are saying that this is a threat to democracy, they don't understand either what the Supreme Court does or what democracy is. So please leave your comments below, like, share, and subscribe. Please follow me on Odyssey, Rumble, BitChute, YouTube, Podbean, Gab, Mind, Substack, Telegram, or Getter, and have a great day, whatever your opinion is.